I do have a proposition, given the time and the areas I need to cover. I do have a speaking note to which I've been trying to stick.
Right.
If you would assist the court, and I've raised it with my learned friend, he didn't indicate any strong objection to it, I can pass it up. Otherwise, I'm happy to continue and traverse through.
Do you have any objection to it? Have you seen it? Or?
I haven't seen it. So
No, I only raised it with him at the door of the court.
Why don't we continue? Let's see at the end whether you think there are points in it that you haven't covered, and then the trouble with that, if there are points that you haven't covered, then Mr. Slade is unaware of them as well. So I think we'll continue without it at the moment, because it sometimes complicates things to have different versions, i.e. your oral submissions as well as the speaking note, as well as the written skeleton. So let's leave it for the moment.
My lord, I raised the issue of the notice.
You did, yes.
And I'm just going to. My lord, it's 492 in the transcript. Page 492, and it's not actually not in the form that I suggested. But if we go to 492,
hold on. Can you just tell me what 492 is?
it's
What your submissions?
Hearing.
We're near the end, so I assume it's your submissions. Is that right?
No, it's the cross-examination of Mr. Qasim Ali, who.
I'm terribly sorry, we're not near the end at all. Yes. My mistake. So it's your cross-examination.
Of Mr. Qasim Ali, who is one of the defendants.
Thank you.
And it's, my lord, it starts, I think, my lord, it is at page 203, so 200 is where it starts. Do you see that? And I think I'm referring to the witness statement.
Yes.
And the relevant part is at B, a question, yes, 200. Now, the 31st, the emergent meeting was called.
Yes.
Do you accept that there was an emergent meeting? And he says, I don't accept this meeting, but were you aware of the meeting? I was. And so we say that
he became aware of it through the media, which suggests he wasn't notified.
Well, my lord, the evidence that was of the notification throughout the trial, and if I'm talking out of turn, the learned friend will pick me up on it, was that there was no real way of communicating. Things were done either by email or by text or WhatsApp, so there wasn't a laid out formula for notification. And you will note, my lords, in the Constitution itself, there isn't a formula by which notices are sent out.
Does he mean when he says it's come to my knowledge through media that I realise there is a meeting? Does he mean he was aware that there had been a meeting because of reports of it? Or does he mean
Well, my
that
lord,
he was
if
aware that there was
we
going to be a meeting?
my understanding, my lord, is that that's the latter, that there was going to be a meeting. Because if we look at the way that the questioning and the answers follow, I begin with, if we begin right at the beginning, yes, 200, that's yes, and then we were looking for Article 7, you see it 200, and then he says 200, now 31st emergent meeting was called. Do you accept that there was a meeting?
But what about what he says over the page, 493 at the top? And in particular, his answer just before C, I'm very well aware that me and other CTC members, including convener, were not aware about this. It has come to our knowledge through media. So the sense of his evidence seems to be, and again, he repeats after C, I was not aware about this meeting. So the sense of his evidence seems to be that he wasn't aware in advance, but he became aware of it afterwards.
My lord, the general position is is that there was an awareness of a meeting. And even if we say that they argue that that hadn't reached them in the formal way or at all, then I will fall back on my default position, which is that no remedy was taken even with that grievance, that complaint.
And just to finish on this point, his answer between D and E is even clearer. No, because this meeting was without our knowledge, held by Farouk Sattar.
Just bear with me.
There is a finding by the judge, too, at the bottom of judgment, paragraph 30, page 93 of the page 92 and 93, in which the judge says the evidence did not establish that any attempt was made to hold the meeting by telephone to include any CCC members in London.
My lord,
So that's the bottom of paragraph 130.
my lord, two things arise from that interjection. First of all, that what I said, that notices were done by phone or WhatsApp, etc. So that confirms that issue. The second, my lord, is okay, we are dealing with the issue, but it is not a pleaded ground of appeal. So in this instance, I mention it simply because the meeting was a meeting that was organised and going on to establish that it followed procedure.
Right.
My lord, the other issue then, before I move on from the Constitution, is the composition of the membership of the CCC, my lord, and that I think is Article 6. Article 6 at page 185. And from recollection of yesterday, my lord, Moylan said that it was 18, and the impression given was that the office bearers were separate from the 15 minimum. My lord, my reading of that paragraph as a whole is that Article 6A, the management of the movement shall be administered by the committee,
Yes.
comprising of the following office bearers, and then it goes on to the senior deputy convener, etc. And then it says members, minimum 15 and maximum as many as required.
So you also mentioned that the members of a CCC are office bearers
Yes, and
and also office holders.
yes, my lord, and they're members of the CCC. And the reason I'm confident in saying so, my lord, is because of the way that the election results are notified, the returns are notified, and the election contested. I'll just confirm that. My lords, if we go to the supplementary bundle 1, and we're looking at page 5 and then page 9. See, if we start off with page 9, this is the notification of the 1st of May 2016. It is prepared for the Election Commission of Pakistan.
Yes.
And the candidates that have been returned are listed there in serial number to the left and the number of votes that they've each received, and then totaled up the total number of votes, etc. We're not concerned with that. What we're concerned with is the candidates. And if you look at the left-hand column, my lord, the name, Nadeem Nusrat, Amir Khan, Farouk Sattar, and so on. Now, these are the people that were candidates and returned candidates. However, the people with the highest votes it seems now on this occasion that page 5, it's the 22, 5 and 6 that were taken to be the committee members selected out of that list of 40 odd. And so the elected members who comprised the committee on the 1st of May effectively were these people at page 5 and 6. The co-opted members were therefore others that had been added in accordance with the Constitution. So the point therefore, my lord, is that if the office bearers are not additional members, that they are elected and then they're chosen from that elected cohort to serve as office bearers. Now the significance of that, my lord, is when we look at the number of people who attended the emergent meeting. And the emergent meeting, my lord, I have to say in our position is that with the emergent meeting, my lord, that was not unlawful. It was a lawful meeting organised in response to emergency circumstances, and that was within the provisions of the Constitution at 13A, where I've taken you before. But my lord, if then we look at the results for the relevant 31st, the minute of the 31st of August meeting, September, my lord, that is in the bundle, supplementary 1 at page 28.
Yes.
And my lord, the first point to note is that this document was a document that's contemporaneous, and the judge at trial recognised the same, that this was a contemporaneous document upon which he placed weight. My lord, the meeting was held on the 31st of August at house number 268 PIB Colony in Karachi. The notice of that variously would have been circulated according to the evidence of the respondents. The people who attended are Mohammed Farooq Sattar, the party leader at the time, Mr. Mohammed Amir Khan, and so on. My lords, we can cross-reference these as whether they are people within the cohort that were elected or not. But the simple fact is that this election, or rather this meeting, passed unanimously the decisions or the proposals that were to amend the Constitution, to expel, or rather to amend the 9A, 9B, and the various other provisions. It certainly wasn't, as being led with the evidence for the appellants, an intention to form a new party. This was to salvage and to rescue the MQM as it existed. And that is exactly what this was intended for. Now, the reason why I took you to the Constitution in the way that I did was that Farooq Sattar was the deputy senior convener at the time, and it was accepted at trial and this appeal that Mr. Nadeem Nusrat was in London at the time. And this meeting therefore took place where Nadeem Nusrat was absent. And in his absence, Dr. Farooq Sattar could legitimately preside over a meeting.
Is it common ground that previously meetings of the CCC could take place with London members attending by telephone.
My lord, that was the custom. Now, that does take me to another point, my lord, which is the record of these meetings. They were recorded by a tape, the old-fashioned TDK tape, and that was a main issue, a central issue in the court below. The advance the meetings were recorded, minutes were kept, but none of the meetings that took place in Pakistan were recorded in the same sense on the TDK tape. So the meetings that took place from London to Pakistan would have been recorded by TDK tapes and minutes, I expect. I have no evidence on that one. But this one, the only minute we have is this minute, my lord. And it seemed not to have taken place with the London people because the London people, we say, chose not to take part.
Do you have any findings by the judge on that as to whether the London members were invited to take part and chose not to, or whether they didn't know about it or the like?
My lord, that was the point that the learned friend raised earlier on, and that's as far as we can take it on that from our side.
So, yes. So your position is that the London members were notified and chose not to take part, but you don't have a finding of fact.
No, because what I would rely on, my lord, is that there was an awareness in the ambience, as that was the custom and practice of the NQM wasn't to advertise or to present notices, it seems, and that was an accepted factor in the court below as well. It isn't something that suddenly was an exigency that arose simply for this particular occasion. My lord, there was a point that arose from a question that was posed by the bench about membership. And looking through the witness statement of the claimant at page 70, that might assist the court in the membership and the composition of the membership of the party as a whole, and the CCC. It's paragraph 17. And the reason I raise that is because it came to mind whilst I was going through the papers, and it's just that so you could have a note, and when you are deliberating, you will be aware. But it certainly says that people who are dual nationals or non-Pakistani citizens cannot take part or be members. My lord, shall I read it into the record for your content?
Sorry, wait a minute. What's the point of that you're trying to get out of paragraph 17?
Yesterday, you asked the questions about the membership of the party.
Yes,
the
but
learned friend did give you some answers, and this is the evidence of the claimant on that point.
When he refers to Article 6 of the MQM's Constitution, is that the 2017?
My lord, that would have been I'm not precisely sure because the exhibits have not been added, but the easiest way to look at it is to look at what we have, and Article 16
is on page 189.
That requires party leader and office bearers to be a Pakistani citizen. But what Mr. Haque says in paragraph 17 is that Article 16 bars dual nationals, and I think that must be an amendment to Article 16.
It may be, my lord, and I don't have all the Constitution.
Right. Okay.
Thank you.
So that, my lord, what we say. So, my lord, I've addressed you on the issue of the requirement of the Constitution to be read in accordance with and approved by the ECP, the Election Commission of Pakistan. So that relates to the validity issue and the grounds of appeal one. My lord, if I could then move on to address you on round B,
1B,
1B.
yes.
So what we say with that, my lord, is, and I've addressed some of that in my opening, is firstly, of course, we say that the current trustees, as they are, do not have a locus to bring or to defend these proceedings as trustees, especially the constitutional issue. With regards to the trust issue, that's a separate matter. It's not a defence to the breach of trust, is the finding of the judge, and that is something that we advance as well. There is, in essence, a failure on behalf of the appellants to distinguish between that. And then I mentioned the fact that the two issues were conflated. The issue of the trustees and the issue of the beneficiaries was conflated. And that conflation is what has led to the confusion in the system.
Sorry, can I be clear as to what you say the two issues were which the appellants have conflated?
The trustees issue, my lord,
By which
and
you
the
mean-
issue of the constitution.
So by the trustee issue, what do you mean?
The breach of the trust,
The breaches
my
of
lord,
trust.
and the constitutional issue.
Yes, I see. Thank you.
The reason that is offensive to the respondent is that where there is a constitutional issue that should have been raised by members, and what we say, my lord, is that we are the members, and that goes back to our central position with regards to the analogy that I gave you that the party continued. I do take on board Lord Moylan's view that trains can be dismembered, but my position on that is that certainly up until the 21st of September 2016, there was a one party, and that has not been just from any odd member, but it has been from D1, and it has been therefore in our position accepted as such. And it has been acquiesced, as I said to you in the Abbott argument. My lord, the issue then is whether or not you wish me to take you to any of the evidence, but bundle 2, that is supplementary bundle 2, 229AH.
Sorry, could you give the page number again?
Of course, my lord. It's bundle 2, page 229A to H. So, my lord, you've been taken to this in the context of the point of view of the appellant, and my lord, I'm looking at it from, just to be safe, from C from C through to H, my lord, and then on the other side, generally from A to D, the end of D. The judge is being addressed, and he's addressing my learned friend, Mr. Slade. The position that the judge takes and alerts the appellants is at the earliest, and he says that at D to E, and in which case we have not actually got anybody arguing the case. The position of the trustee is not to argue that. Their position simply, I recognize that there is a trust to hold these assets on behalf of Mutahida Qawmi movement. We now need the parties who are arguing, who are the beneficiaries, to argue it. And my lord, our position is we are, of course, the party to argue it. It's the trustees who don't have a defense, at least at that point, on without a representation order and or identifying who their membership is. We don't actually have a direction from the court that says the MQM London is represented by these people, and this is the MQM London's membership, and this is what they represent. On the other hand, the claimant has valid authority from the MQMP. Now, if the court is with me on that point, that the MQMP is the development and successor, just a mere name change, then of course, my lord, the claimants do have locus to bring this claim and to be the beneficiaries of the trusts as argued for. My lord, it also ties in with the fact that if the MQMP is the MQM, then, my lord, the reason why the judge came to that decision is because of the evidence that was before him, which established for him that the MQM was the MQMP, and that is the evidence that I've taken you to and the argument I presented before you. If he needed to look for a legal argument, my lord, well, that would have been if the overwhelming evidence denied him the rhyme and reason for coming to that conclusion. That is the argument and the sprint room argument that my learned friend has put in his supplementary skeleton argument. And my lord, my answer to that would be twofold. Of course, the caution that sprint room contains is that the lower court should be cautious about disturbing the bona fide facts of a judge in the court below. And that is amply demonstrated in sprint room. But my lord, the other point to take from sprint room, and I'm just trying to find the authority for you. I think it was handed in very late, so it's not on my list.
It's in the authorities bundle. Sprint room.
Yes, it is at 169,207. I think the relevant paragraphs I wanted to take the lordship to was 17, paragraph 15, 17 and 18, my lord, are the paragraphs that I wanted to particularly draw your attention to.
15, 17 and 18.
Yes, my lord, I'm just trying to find them here. My lord. My lord, I may be looking at the well, I seem to have misplaced the paragraphs. Forgive me.
The paragraph that's most usually cited from Sprint Room is paragraph 76 on page 190.
Well, 76 may be, that might have got that bit confused with spring and still and das. Oh, 74. I'm sorry, my lord, it is 74, I put in my speaking notes. Yes. So, my lord, 74 and going on, it quotes Sir Timothy Lloyd at the 3rd of August 2017 in paragraph 74, and it says 417, the submissions for the RBs was that the appellate court should only interfere with the trial judge's primary findings of fact or with conclusions based upon an evaluation of facts if it is satisfied that the judge was plainly wrong, exceeding the generous ambit within which a reasonable disagreement over the evaluation of facts is possible. This was to be justified by the well-known case of Ascurisioni General SBA versus Arab Insurance Group Practice Note 2003. The RBs also relied upon the decision of the Supreme Court in Henderson and Foxworth Investments Limited. In 2600, in which it was held that in absence of some identifiable error, such as a material error of law or the making of a critical factual finding which had no basis in the evidence, an appellate court would not interfere with the factual findings of the trial judge unless it was satisfied that his decision was plainly wrong in the sense that it could not be reasonably explained or justified, and so was one which no reasonable judge could have reached. We invited the parties' attention, in addition to these cases, in the re-B child care proceedings,
Yes.
threshold criteria, and so on.
Yes.
Now, my lord, I said right at the beginning of my opening that the judge's findings were based in reason and logic. He'd gone through the findings, he'd gone through the process of the committee, he'd gone through the process of listening to the evidence of D1, and he came to the conclusion that there was no new party, therefore, on his sound reasoning, there was no need to go further. His finding that there was no new party is coinciding with the case that the defendant, D1, has accepted.
Yes. Thank you.
So, my lord, if I could say that I've dealt with that particular issue, round 1B, unless there's anything you wish me to clarify, I did say, well, at 3:30 I should be wrapping up. So I will move
Don't
on
worry.
to round 2 of the appeal,
Yes.
if I may. Now, my lord, we say with confidence that you will accept that the letter at page 18 of the bundle, supplemental bundle, the core bundle one, is the letter that says, I step back, I resign, and that, my lord, is the English version. I believe it is page 18.
It's page 18 of the first
Yes,
supplementary.
the first supplementary bundle. This was originally produced obviously in Urdu, my lords, and it's a matter of fact, undisputed, that in its Urdu form, it remained on the website of the defendants at that time for at least until the 20th or so of September 2020, from when it was first put up. It wasn't in any way shaped, altered, or amended. It came down from the website, and the translation is I hand over complete authority, organization, decision making, and policy making to the contact committee, and that is the Raptor committee. It's a misspelling of the contact, but the Raptor committee at Altaf Hussain. And then I will read the relevant bits only. I will pay special attention to my health as per Raptor Committee's advice, Altaf Hussain. Owing to the ongoing incidents, sad news, and the day and night organizational activities, I'm under immense mental stress, Altaf Hussain. Then it says, I maintain my promise that Pakistan was my country and still is my country by the grace of God, Altaf Hussain. My lord, what do we say about that letter? The first thing we say about that letter, my lords, is that that letter is unequivocal, and we plead it as such. It doesn't contain the ambiguity that you're now invited to impute into it. You are being asked to look at it afresh and find in it that this was somehow a temporary move, that this was a move which had such repercussions that it would render the decisions of the 31st of August and the 1st of September invalid. And the counter to that, my lords, is twofold. The counter really, and my lords, the judgment deals with it at page 89 from 112 onwards, although it may start at 88 at 109. But the substantial matter of it is in between 109 and then 1112, 112 and 115. The letter of resignation is one that says Altaf Hussain no longer is involved in these affairs, doesn't take part in them. He has stepped down. He's no longer a member. It doesn't say that Altaf Hussain will come back. Altaf Hussain will resume after a break. It's written in language which is quite clear. And the reason why we say it is clear, my lords, is it's not only that this letter was then presented to the press and on their own website, but reliance was placed on this letter to write to other authorities, the Metropolitan Police, the inspector at the time, or the superintendent of the Metropolitan Police, a Mr. Rafar, who was their lawyer, wrote on behalf of Mr. Hussain to say that he had effectively done what he says in the letter. he also holds a telephone conversation with the then ambassador of Pakistan in the United States, Mr. Haqqani. And the judge has made findings to that effect on all of those points, which supports the contention, my lord, that Mr. Hussain chose at that moment, he may have regretted it since, and he may still regret it, that he resigned. And he gave up all his power and vested it in the alternative in the CCC. The CCC was a sovereign body and it's accepted as common ground. The CCC is a sovereign body in the Constitution and in the organization in any event. The role that Mr. Altaf Hussain had was an honorific guidance, a visionary. But it did not mean that if the executive committee or the CCC chose to ignore his advice, that advice would be rendered illegal. That advice would be rendered null. You're asked to put all of that into this letter and relate it to 9A and 9B, which I'll be addressing in the context of this letter.
What Mr. Slade submits is that the judge in paragraph 116 deals or sets out that there was an issue between the parties as to the context for this letter, and in particular what had been said or not been said in the course of one or more telephone conversations. And it said that in failing to address that, the judge failed to address an important material aspect of the context of this letter or statement for the purposes of determining what it meant.
Well, my lords, I heard that submission and I'm grateful for you reminding me. My position on that is, my lord, is that the telephone conversation, we don't have a record of that telephone conversation. It's never been adduced in evidence. Now, my lord, it's even more significant when I took you to the witness statement of Mr. Saeed Amin al-Haque, and we talked about the TDK tape. If the telephone conversation took place with, as supposedly did take place, with Farouk Sattar, then there would be a record of it because every single phone call, this is what was said, phone calls were recorded.
Well, that seems to be a submission that there never was a telephone conversation. Whereas the judge seems to have found that there was, he just made no finding as to its content. And also he seems to leave open the possibility that there was more than one.
Well, my lord, that is even more intriguing, because if we look at it in the context of things, this was a very important telephone conversation. The contents of it would have been a momentous moment for the party.
Well, can I be clear what you're submitting? Is it your submission that there never was a telephone conversation at all?
My lord, if I said that, there's no evidence to say that there wasn't a telephone conversation. So I would say that there was a telephone conversation, but the content of that telephone conversation has never been presented in the way that is now being advanced. And it would have been very easy, very simple, to have found that. My lords, if we look at the way that the judge dealt with the issues of the TDK tapes, we went before Lord Justice, Mr. Justice Leach, who ordered that tapes that were recordings that were made, copious numbers that were made, they were produced on the basis of an unless order. Now,
Yes.
in this particular instance, that telephone conversation would have been most advantageous, but it's not been provided. A, because if it took place, it doesn't support the contention that has been advanced or the importance that has been assigned to it, or B, it doesn't exist any longer, and we shouldn't be venturing into supposition as to the contents of that conversation.
I mean, as you recognise, this was, as you say, a momentous moment in the history of the movement, and in that context, this was, as you correctly identified, a very important telephone conversation or conversations.
Yes, my lord.
Yes, yes.
So, my lord, the context then, therefore, is what difference did it make? The letter doesn't say in the Urdu form, if the English is the correct translation and it's been accepted that this is the correct one that we worked from in the lower court and today before you, it doesn't say, oh, and it is qualified. It doesn't give context other than that I'm not well and other than I hand over complete power. Then, my lord, therefore, you are being invited essentially to impute into this letter something that isn't there. And my submission on that is you should read it on the face in plain English and ascribe to it the plain interpretation and construction that is there, not qualified with any superlatives or gloss. Then, my lord,
This was a statement addressing Mr. Hussain's role. The Constitution also contains a provision dealing with his role.
my lord, that's
How
not,
do the two fit together?
that's where I'm going, my lord. With
Right.
9A and 9B, I
Yes.
think, my lord. If we turn to page 189, that's where the Constitution,
Yes.
the article is found. Sorry, not at 189. It's at 187. And my lord, the clearer text of 9B is at 182.
Yes.
So if we start off with this particular wording, my lord, it says 9B of the April 2000 Constitution as found by ICC Jones at paragraph 97 of the judgment dated 13th March 2023 reads, the Central Coordination Committee shall seek guidance from Altaf Hussain, being the founder and ideologue on the major issues for his ratification. And that fits in, my lord, with what's been commonly described as Mr. Hussain's effective veto power. That is to say, if I don't give advice or if you don't procedurally follow the advice or the route of 9B, that particular procedure is void or voidable. And what we say, my lord, is that is not the case in any event. It is and it's been accepted this morning and to credit in the lower court, the supreme body of rulemaking is the CCC, and 9B and 9A were read together, read exactly that. Mr. Hussain's role as a visionary, as an ideologue, is voluntary, and we say that it is one that can be overridden by the committee in any event because they choose the major issue. It is they who make the decision whether or not to accept that advice, and it was accepted very blankly properly today that the CCC could sidestep that advice. It's not bound by that advice. Now, if we then look at the issue, did this letter empower the CCC to even consider that? This is our understanding. And we say that with the letter vesting complete power, and my lord, I reiterate, I hand over complete authority, organization, decision-making, and policy-making to the contact committee, Raptor Committee, Altaf Hussain. Well, there's nothing equivocal about that, nothing ambiguous about that. The power or the discretion that Mr. Hussain had, he voluntarily gave it up for whatever reason that was his. He has the prerogative to do so. He therefore vested or said to the CCC in the alternative, I'm not required. You don't have to consult me. You're sovereign in any event. So our position, my lords, is that if we look at this, it's power that perhaps was had, but power given away voluntarily and not given back. And this is one of the facts, one of these facts that contributes to the judge's findings of on the constitutional issue. He wasn't required to seek the committee wasn't required to seek the advice of Mr. Hussain to amend the constitution. He no longer had that role. It would be quite to the contrary to say, and perverse, to say, I've given up the power, but somehow or the other, I have a power and you must consult me. That's a perverse and illogical submission in my submission to this court. You cannot give something away and then say, well, hold on a minute, but I've given it to you completely, this power, but somehow I have some peripheral role in things to do with that power. Our position, no, it isn't. So any decision taken after the 23rd of August, when this letter effectively became effective, there was no need. And therefore decisions taken since Mr. Hussain's visionary advice are valid, are complete. And my lord, there's nothing else I can add to that.
What if the committee didn't accept it and said no?
If the committee said,
we still want to seek your guidance.
well, my lord,
They could do that?
There are two instances, my lord, that illustrate that.
This is a hypothetical question.
Yes. Well, if we look at it in hypothetical terms, my lord, the committee is accepted to being the sovereign body. As a sovereign body, there seems to be no fetter on its power. So it's conceivable that the committee could say that. But in this instance, the committee has not said that. And furthermore, my lords, Mr. Hussain, as a matter of fact, and he says it in his own witness statement, quite plainly and boldly, I resigned twice before. And the judge has noted that. And that has added to his conclusions, supporting his conclusions, that Mr. Hussain could resign and give up the role. And the fetter, there was no fetter on the workings of the CCC in the absence in that interim. Because it's not been argued, and I can see why it's not been argued, and that issue's not been raised. But if Mr. Hussain resigned twice before, well, what about the decisions then that were taken when he had resigned? Why should it be different now with regards to these elections and these amendments? Furthermore, my lords, the difference here is on those two occasions. Now, this is demonstrating the power of the sovereignty of the CCC. The CCC asked him back. On this particular occasion, they didn't. And he still hasn't been asked back. So the position, therefore, my lords, is that letter of the 23rd is as good as a resignation, a permanent resignation, a permanent surrender of power, and therefore devoid of any influence over any decisions that the CCC may make or take.
Yes.
I'm just seeing if there's anything else I need to add. So, my lord, the Donovan issue, the issue with Donovan and Grain, I believe that's Authorities Bundle, page 39. And the paragraph is 33. At the bottom of the page.
Yes.
So the judge considered next whether Mr. Donovan had repudiated the joint venture agreement as a result of one or both of his emails aimed at 1506 on 26th of January 2015 and his failure to continue working on the joint venture from around Jan-Feb. My lords, the rest of the paragraph I leave you to read for saving time. The point I make with this particular issue, my lords, is twofold. Again, Mr. Hussain voluntarily chose to do what he did, which was to tender his resignation unconditional. But also that Mr. Hussain held no post, or it was not an office bearer. His position cannot be compared with that of a director or a participant in the same capacity. Therefore, my lord, it isn't something that will assist the appellants in supporting the contention that somehow Mr. Hussain could be restored and that stepping down from the joint agreement could be seen as temporary or perhaps permit him to take some passive role in running or influencing the CCC. That is not what the facts contained in the letter and in the before the judge at trial. My lords, if I can indulge you one more time to go into Supplemental Bundle 2 at page 488, 8E.
Sorry, can you give me the page again?
My lords, it's 488, Bundle 2. So, my lord, this is dealing with the cross-examination of the 6th defendant. And it's asking here about the decision-making of the coordination committee and the Veto on it. I can leave you to read it for yourselves, my lord, or I can go and talk you through it. But I prefer to utilise the few minutes I have with...
Well, don't worry. So what are you, sorry, which bit are you referring to?
My lord, it's from A to E, and we say that at 6:02, where does it say there's a limit in time in some way? So this is referring to the letter of the 23rd, and we're looking at, if I can just read it out to you, Mr. Mohammed, I'm very grateful, my lord. So where in this letter, Mr. Ali, let us look at it at 6:02, shall we? Yes, at 6:02. Where does it say that this power is limited in time in some way? And he replies, but it is not mentioned that Mr. Hussain is given power to change the constitution of the MQM and remove his name from the constitution. Where is it in this letter? Is it not mentioned as well? This is because now Mr. and then the judge interjects. Let me ask the question again. Well, he has, it's not there. There's no power, there's no limit. So this is the point from the sixth defendant.
Who also makes the point that Mr. Hussain not mentioned that he'd given the power to change the constitution and remove his name.
My lord, that is a point that arises from there. Our position, my lord, is that that is not something which was in his gift in any event.
Right.
So that is irrelevant. That's just avoiding the question.
When you say his gift, you mean Mr. Hussain's gift?
Mr. Hussein's gift.
Right. Not in his gift to change the constitution.
No, the power to change the constitution, to give that power to the CCC to change the constitution. Remember, my lord, that has to be in the context of the fact that the CCC itself is a sovereign body. And Mr. Hussain accepted in his evidence, and I quoted you to his evidence, that he was subject to the constitution, to that contract. So therefore, he must also accept that that is the position. My lord, if I can, with your leave, move on to the issue of the construction
Yes.
of 9A, 9B, my lord,
3.
round 3.
Yes.
My lords, the ground 3, I'm just trying to find the judge's reference to it.
It's
My lord.
134, is it?
It's a 133 is where it,
Yes,
It's
where he
stated.
sets out.
yeah, the way it
Yes.
sets it out. And my lord, if I can just take some moments to address you on that particular point there at 133, then we
Please.
can move on. My lord, this is a matter of construction. We're looking at the wording. The CCC shall be the highest policy and decision-making organ. We've accepted that as common ground.
Yes.
It then says its decisions shall be binding on all party organs and members. Ordinary decisions shall be made by simple majority. Well, the first part of that is all members are subject, including Mr. Hussain, are subject to the decisions. Ordinary decisions, now that's the point that we need to be looking at. Ordinary decisions in a meeting shall be by simple majority of members present. And then that is fairly simple, and I don't think it's controversial between parties. That's there. The controversy arises in the second limb.
Yes.
While in the important and major policy decisions, 2/3 majority of the committee shall be required. My lord, that we say is a reference to those people the judge quite rightly finds at 134, I think it is, in the order, yes, 134, rightly finds that the members or the reference to the committee is not a reference to the whole entire committee. It is a reference to those who are present in the meeting, and that was the emergent meeting on this occasion, where there was power for organizing, and there was provision for organizing it, and it was organized. And what we say is the people who were present are the people who are the ones that are to be taken into account, not the entire committee spread throughout the world, London or elsewhere.
if you look at the wording as it is actually in the Constitution at 187,
Yes, my lord.
the first sentence says the committee shall be, so it's referring there to the committee as a body. The third sentence says ordinary decisions, a simple majority of members present, and then the last sentence refers again to the committee. So it might be said that when referring to the committee in the last sentence, it's using it to mean
The whole committee.
all exactly, the whole
No,
committee.
That's not how we see it.
I understand that, but you see why it's repeating the word committee,
Yes.
it's distinguishing in the middle, saying simple majority of members present. So if the intention had been that it would be 2/3 of members present, it would have been quite easy to put that in.
My lord, it may well have been, but what we're ignoring is the conjunctive, the while. My lord, if we read the as it's set out in the 9A, while in the important and major policy decisions, 2/3 majority of the committee shall be required. And what we say, my lord, is that the word while, the verb, changes the relationship in that sentence from being isolating one or the other, but it actually is to be read that the committee, when it takes minor decisions, they are perhaps by a less formal procedure, i.e. a nod, perhaps, or some other simple procedure, but in a scheduled meeting, the important decisions that arise, policy decisions or others, a 2/3 majority of those present should be what would raise their hands or vote, whatever. So we say that the conjunctive word while is not a disjunctive. It doesn't say there that it's a reference to the committee itself. It is those members of the committee that are present while they're present is how our submission is. And we say that that has force because, my lords, if we look at the Constitution further in reference to other points, the 2/3 majority.
Yes.
Well, my lord, the point that it's got to be taken into account is the fact that vacancies in the committee itself are co-opted. Now, the fact that a committee can exist without a member and therefore be deficient, but vacancies can be fulfilled. But whilst that committee is not to full strength, its majority fluctuates. It could be a 2/3 majority of 20, it could be a 2/3 majority of 18, or what have you. But the simple fact is that to avoid that situation where the committee is constantly looking over its shoulder to say whether or not a committee is to full strength, it must have a mechanism to avoid that. And that is what the 9A and the word while is suggesting.
So I'm not sure, speaking for myself, I entirely follow that, because the committee comprises whoever is in the committee at the time. And if a member has resigned or sadly died, then the committee comprises whoever remains. And so that doesn't, I'm not sure how that assists on
my lord,
the 2/3 majority point.
Our position, my lord, is that if the committee is to say that a 2/3 majority is required for all major decisions at all times, and its membership fluctuates, then unless, of course, it says, well, look, the 2/3 majority moves with the, as you said, my lord, with the constitution of the committee, then that's fine. It will work in that scenario. But what we say, my lord, is that's not what is envisaged here. The clause here says quite clearly that because you cannot be saying that a scheduled meeting, which the emergent meeting was,
Yes.
could not take ad hoc decisions because that is what it was gathered for.
Can I, another question, Article 10 says that the Constitution can't be rescinded or amended except by a 2/3 vote of the committee. Does that
Well,
mean the whole committee?
My lord, my position there, again, is it would be inconsistent to me to say no. That my position on that is that people who are present,
Right.
who are legitimately members of the committee, 2/3 of those would be sufficient to validly carry a
There's no
decision.
while, it's just simply a freestanding
It's a
provision.
freestanding.
Okay, and so you make the same point as I think you just did 13B. Until regular elections, the committee shall fill existing vacant offices by decision
by
of at least two-thirds majority. And that again, you say means of members of the committee who are present at.
Any given meeting. That is a scheduled meeting. It could be a scheduled meeting that's emergent, a scheduled meeting that is gathered, and an annual general meeting. Now, the meeting that took place post 2016 September 1st, what isn't recorded there, my lords, is whether that was an annual general meeting, an emergent meeting, or ordinary meeting. However, it was a meeting, and that's for a fact. I couldn't raise any further points on that, but what I would say, my lord, is that if the 9A is construed and it is interpreted the way that I put forward, then, my lords, there was no need to consult Mr. Hussain. B, the conjunctive while says that those people who were present, and the judge was correct to find that that is what the issue was, that people who were present took part. And their decision was therefore unanimously carried. It wasn't a question of 2/3, it was carried by a unanimous outcome on that particular occasion. If I may just turn my back.
So, a final question on this theme. My lord asked you about Article 10 and 13B. Can I ask you the same question about Article 17? Because at the top of page 190, we see that an aggrieved member has the right to appeal to the entire committee, and I emphasise the words entire, whose decision with 2/3 majority on this matter shall be final. Now, again, does that mean what it says, or does it mean
My lord,
2/3 of those present?
there's a distinction. My lord, it is something that I had not noticed, but I'm very grateful that, my lord, you have brought it to my attention. Because if you look at it, here, it makes it very plain. The emphasis is on the entire committee, whereas in the other two clauses, the procedural clauses, it's not the entire committee, it's reference to a committee in generic terms. And so therefore, my lords, I couldn't quibble with that to say it doesn't mean the entire committee. And it may be a perception that the grievance of a member perhaps it outweighs all other decisions that the committee needs to make, and it's of such gravamen that it must be addressed by the entire committee.
Right, so as I understand it, your position on Article 17 is you accept that that requires a 2/3 majority of all of the committee, not merely those present at the meeting. But you say there is a distinction in the wording, which is the presence of the word entire. We don't see that elsewhere. And of course, you're absolutely right to point out that there is a difference in the wording there. But on the other hand, what would you say to the point about the fact that the majority in all of these provisions is 2/3? Is it intended that it be a different 2/3 in the different provisions?
My lord, if we say those, and I think I've addressed that issue, but I'll reiterate and I'll try and be slightly more articulate about it. The 2/3 majority of the committee to anything other than 17, the Article 17, in my submission, means those who are present in a scheduled meeting of the committee. And the reason why I say that, my lords, is if we look at 17, again, Article 17, page 190, it begins, my lords, on page 189, intra-party dispute. Now, this is an interesting situation. The reason why it's an interesting situation and distinct from the nature of an ordinary meeting is this is a meeting that's convened not as a meeting of the committee to discuss administrative matters, but matters of regulation. But this is a matter essentially of discipline. And
well, and the disciplinary matters are important. And so one can understand, trying to understand the purpose of voting threshold, one can understand that it's important to have a relatively high threshold in disciplinary matters. But then the question I would put to you is this. Now look at Article 10. And it says that an amendment of the Constitution requires a 2/3 majority. Is that not even more important?
my lords, it's not, it's the emphasis is not for me to add or for the court to impute. The reason why I say that, my lord, is the difference in 17, the text of 17, it specifies entire. My lords, if the draftsmen of this constitution intended to put such emphasis on the amendment, then it would be just as easy to say that the entire committee, but not just the committee. So, my lords, it may be that both are just as momentous, but there must be a distinction in the minds of the draftsman and the party and the committee who ultimately agreed to this constitution. So, my lords, I hope I've answered that question to say that there is a distinction between the requirements of 17 and the other clauses. And therefore, the reference there is to scheduled meetings. And scheduled meetings seem to be 2/3 committee only, whereas a disciplinary, which is not a scheduled meeting, which is a meeting of a different nature, requires a different purview. My lords, I'm just checking my notes to see if there's anything else I need to address you on. I'm coming to the time.
Thank you.
So, my lord, I will leave you with Brown, a new quadrant at paragraph 68 as regards to the decisions and this particular issue of a momentous decision. To 31. It's paragraph 68.
Paragraph 68.
Yes, my lord, 17. My lord, it's 60, sir. 60 and 67 to 68, but I'd like to take you to the to paragraph 60 and 61 first, if I may. And this deals with the issue of a momentous decision that the trustees may take or would take. And I'd say that this is the applies equally to the committee, that they're taking a momentous decision. And therefore they would be paying it consideration, a greater consideration than its other decisions that they take. But nonetheless, it's quite to the point. I realise that
Well,
refers
sorry,
to trustees.
I'm sure it's my fault, but I'm not following this. I can understand why you say that the provision in the Constitution for 2/3 majorities is affecting momentous decisions. Okay, I follow the logic of that. But this authority that you just referred to is about where trustees are applying to the court for the court to approve a particular course of action.
My lord, it was just by analogy.
And why? You say there's an analogy there. All right. Okay.
My lord, I'm just checking to see if there's absolutely nothing else I've left out, then I will be on time. I think, my lords, I've covered everything that I needed to cover grounds-wise, appeal ground-wise, and the preliminary notes. Unless there's anything you wish me to specifically address you on.
No, thank you very much, Mr. Arnold. Thank you. Yes, Mr. Slade.
Arnold, at the start of the hearing, you gave me permission
I
to
did.
put in the
Yes.
supplemental appeal
Yes.
skeleton, and that gave my answers at that stage to the preliminary issues.
Do you have anything to add to that?
No, I don't have anything to add to them.
So you rely on the matters set out?
If I could rely on the matters set out in that document, there is one update I need to make to paragraph 12 on page 5.
Yes.
I refer there to a rule of the Supreme Court,
Hold on.
19.7.
Yes.
I don't know whether I mistyped that or whether it was at the time I originally looked. It was 19.7, it's since changed, but the rules instead I think would be more relevant, would be 19.8 and 19.13.
I'm sorry, I've missed the place you're referring to.
It's in my supplementary skeleton, paragraph 12.
Yeah. Oh yes, I see. Yes, it's 19.8.
19.8, which is representative parties with the same interest.
Yes.
Yes.
And then also I'd refer to 1913, power to make judgments binding on non-parties. So these were.
It strikes me this is quite a subsidiary point.
It is a
Yeah.
subsidiary point. But had you looked at 19.7, you were wondering if that's going on.
Yes.
Otherwise, if I could invite you, please, just to read what I say in the supplementary appeal skeleton argument and take it as if I'd
Thank you.
made exactly the same submissions in court.
Yes.
On the grounds of appeal themselves, the discussion that you were having with Mr. Mohammed on ground 3 raises the question as to the meaning of the word committee, and the same answer in my submission should be given both in A, last sentence, 9A, last sentence, in Article 10, in Article 13, and in Article 17. It means a 2/3 vote of the whole committee, not just those present in a scheduled meeting. And in our defence, it is actually Article 10 that we rely on. That's the rule that applies to rescission or amendment of the Constitution. But I note that the judge's finding was on Article 9A. And so I suppose there is the possibility that your lordships might decide, well, there is a different meaning to be given to Article 9A, the word the committee there, to Article 10.
Ah, this is kind of an important point. And speaking for entirely for myself, I've been a bit slow in spotting that distinction. But so how does that play out? Because up until you made that point, at least the way my mind had been working was, the ground of appeal was concerning 9A.
Yes.
Whereas if I mean, in other words, that you just to rephrase what I'm saying so it's a little clearer, the point you're now making, if I've understood you correctly, is that even if you're wrong about 9A, you should still win because the applicable provision is Article 10, and that's clear.
Then we're in the position that the judge didn't make a finding about Article 10 in the wording of his judgment. Now, I think he assumed that he was addressing the question of what was the required majority in paragraph 134 of his judgment.
It is Article 10 that is relevant, because what you complain about is the amendment to the Constitution.
Article 10 is certainly
It's the removal of
it is the relevant article, although equally we would say that it's an important and major policy decision, and exactly the same majority would apply to that.
And just sorry to interrupt you, but just before I forget, I've now reminded myself, and I had completely forgotten this, despite the fact it was me who gave permission to be in the first place. Actually, this is in your grounds of appeal. So if we look at the grounds of appeal, page 16, although the heading to ground 3 is judge misconstrued demeaning committee in Article 9A, and that's the focus of paragraphs 13 and 14, you in paragraph 15, you make the point about Article 10. So
right.
it is there. I have forgotten.
Well, yeah, no, I'm afraid I've forgotten that as well, because perhaps I haven't said it in my skeleton. But there we are. We're inviting this court to conclude what 9A and or 10, certainly 10, but possibly 9A as well means in the word committee. You don't have to reach the same decision for both, but I submit that you should. I'm grateful. Now, during the course of the hearing, this is now the subject. If we were to succeed in our appeal, what order should your lordships make? And I don't want to be presumptuous by going into this, but we have already discussed it to a limited extent in the court. And you, my lord, raised that question at the very outset.
Quite.
So I've jotted down what I would describe. I'm afraid I haven't shown it to Mr. Mohammed yet, but I've jotted down in print that is much too small. But may I hand up some what I would describe as provisional draft for what might be a framework for one part of any order, emphasising that I am not assuming in any way that my appeal is successful, but nevertheless this is just as a matter of practicality to try and focus on the relief that which we are seeking.
Yes, well, it's always relevant when this court is considering an appeal to understand what the potential consequences are if one or more grounds are upheld.
Yes, and first, before we look at this piece of paper itself, my Lord Justice Nugee suggested that I go through the paragraph 182 in order to identify which parts we would accept stay and which parts go if we succeed in our appeal. And the only part of these decisions which would stay if our appeal succeeds is B and C would stay, and the first sentence of I would stay. All the other paragraphs would be overruled.
Well, presumably you would accept E. You're not inviting us to decide that the resolutions passed on 31st August and or 1st September breach the Constitution. You're inviting us to remit that.
Yes, you're right, my lord, but that is also in connection with ground 3. So we
Yes, but you're not inviting us to add up the heads and see if it comes to 2/3, because there are whole sorts of disputes.
yes, no, we're not. No, we're not. No, we're not. So looking at the frame, the provisional wording I've handed out, and I'm sorry the typeface is so small. Paragraph 1 speaks for itself. Paragraph 2 is an attempt to identify the purpose of the hearing, to make it clear that it is confined to the constitutionality of the 31st of August, 1st of September amendments. And paragraph 3.1 reflects the judge's findings in
Yes.
B and C.
Yes.
3.2 reflects what we invite you, the findings we invite you to make under ground 3 of our appeal. 3.3 this relates to ground 2 of our appeal.
Yes.
Do you feel able to say that the announcement had no effect, in which case you would choose the first option on 3.3, or if you feel that there is an important matter of factual context, then you would choose the second option.
Yes.
Under 3.3, and then under 4, this conclusion follows, we submit, if you, in the event that you allow our appeal under ground 1A, it follows that the judge's conclusions as to the impact of events after the 1st of September 2016 have been overruled. Then after that, we apply to the High Court for further directions on matters which may include those in the judgment, paragraphs 176, and that is the paragraph where the judge is detailing what he considers to be the unsatisfactory and confusing state of the constitutional issue as presented to him. And we also mention 177, but could I correct this draft in that I would submit it should be confined to 177A.
Because you're not suggesting that Pakistani law should be investigated.
No, that time for that has long gone.
Yeah.
So that is why I'm seeking to exclude B. But A was clearly something that deterred the judge from getting to grips with the constitutional issue in a way that he could decide it. And at the next hearing, the judge may well wish to get to grips with those issues.
Yes.
So although it is a very provisional draft, that's
Yes.
the sort of framework that we would be proposing if we met with any success on this appeal.
Thank you. Yes.
May I just take instructions? unless I can assist your lordships in.
I have just one thing which Mr. Mohammed said, which I'd like to have your observations on.
Yes.
Among other things, he said that it's inappropriate, I'm paraphrasing, for the English court, this touches on the point you've just referred to presume to itself to decide things which were properly the province of a constitutional organ of Pakistan, either the ECP or the courts of Pakistan, and that the English court really shouldn't be going there. And I just wondered what your reaction, what your reply to that point was, which is a rather different point from the other points you made.
The reply would very much match what I say in my supplementary skeleton argument under preliminary issues E and F. Essentially, that the claimant submitted to this jurisdiction to decide the constitutional issues, and so it is now far too late to say that the English court should not exercise any jurisdiction it may have over those constitutional issues, because we've already gone a long way down the line, and indeed the judge has already decided things. For example, he's decided which is the constitution which applies. So the English court has already accepted jurisdiction over this matter and shouldn't stop now. The idea that there is some issue in this case which must fall within the exclusive purview of the Pakistan courts has never been pleaded out or argued at a jurisdictional hearing. And nothing along those lines appears in the statements of case, and there's been no jurisdiction application. So it's all far too late to say it would be much better if it were the courts in Pakistan looking at this rather than the English court. There is, of course, the reality that first defendant and other defendants and his supporters are not welcome visitors to Pakistan. They have come to this country, claimed asylum in this country, and their chances of getting justice in any court in Pakistan is greatly reduced or questionable.
Well, we're not in a position to investigate that or to make any decision about it, as I'm sure you would accept.
I certainly accept that.
But more fundamentally, I mean, as I understand it, to put what you've submitted both in writing and orally in a slightly different way, what you're saying is that never mind procedural questions, even as a matter of substance, there are two different questions which must not be confused. The first question, which is the one that arises in these proceedings, is whether this claimant, as representative of those he claims to represent, has standing to bring a claim for breach of trust before this court against these defendants. The second question, which is quite different, is who can validly act as a political party in Pakistan in accordance with Pakistani law. And I presume you would be entirely content to accept that a decision of the English courts on question 1 doesn't affect in any way question 2.
No, it does not affect it. It doesn't affect it anyway.
No.
MQMP, we acknowledge, is a registered political party in Pakistan. It does act as a political party in Pakistan, whereas MQM is not. So it does not conform with the election requirements in Pakistan, cannot take part in elections in Pakistan. But what your lordships are deciding are for the reasons given by Arnold, nothing to do with that.
Yeah.
Well, and also it could be described as a procedural issue. Locus is procedural, and that would be governed by the law where the proceedings are taking place, as a general proposition. Yes.
Yes, thank you.
there was a hearing, I'm reminded, we had an interlocutory hearing before Master Clerk, security for costs, and we were awarded our security for costs on the basis that we would have difficulty in enforcing any judgment in Pakistan, and that authority is in the authorities bundle, actually, although it does come exactly from these proceedings. And there you can see the sort of grounds on which it was argued that the defendants would not be able to enforce their cost order in Pakistan. Their access to justice would be restricted in Pakistan.
Might not be able to,
Might not be able to.
because security of costs is about the risk of non-enforcement.
Yes, I accept that.
Thank you. Mr. Mohammed, I'm not inviting you to respond to this now because you've only just seen it, and this is obviously going to be consequential on our judgments when you receive them. But is there anything immediately you want to say?
Not my lord.
No. Okay. Thank you very much. Well, Mr. Slade, Mr. Mohammed, thank you both very much, and those behind you, for your respective, and if I might say so, comprehensive and eloquent submissions. We will be reserving our judgments. They will be provided to you in draft in the usual way, and just to emphasise, they are provided to you in draft for the purposes only of correcting typographical errors and not for any other use. And any other use would potentially be a contempt of court, as set out in the case, the name of which temporarily escapes me. Counsel General for Wales. So it is important, given the issues engaged, and I understand the strength of feeling, that that is recognised and adhered to. So,
My lord, before we finish the amendment to the slip so that I can add Mr. John
yes,
Shane's
can you
name.
do that once we leave court? But subject to that, we would hope that once you receive our draft judgments, you will be able to agree a draft order, whether in this form or another form, but if not, we will deal with any outstanding issues on paper. So I think that concludes the hearing today. Thank you very much.